we will be treating to be guided by where it is the point that the feels victimized on social media and has requested before the accused person is released. That, Your Honor, will be a change of circumstance where the accused person can approach this court after the complainant has testified to seek for bail and bond. Your Honor, you will also note that we did serve the affidavit. We have not received a formal response to that affidavit. We have also not received a formal notice to cross-examine the deponent, and we will thus be seeking the court to be guided by the averments in that affidavit.
Mine is just a few things. And I wish to invite the court to look at paragraph 8, subparagraph A. While we are telling the court that the accused person is a flight risk, we hope the court has had the benefit of seeing the video that has been circulating concerning the offense. And the accused person committed the offense around the morning hours. He was not arrested until the hours of night, for the very reason that he went into hiding. The police officers were scouting for him until they got wind that during the night he had made his way to his mother's house. And this is a demonstration of the capability of the accused person. Well, Yola, I would wish to speak for the victim. I know Mr. Mari is here. And to ask the court, yesterday when we were in court, members of the, I don't want to say the members of the family, but they were coming for the accused person. They took videos which ended up on sites like Tuko. And these efforts are just re-victimizing the complainant. We wonder what will happen if he is let out at this point. A mockery is being made of this case. Actually, this case is such a serious offense. In other jurisdictions, it attracts even a penalty of death. Yes.
Which jurisdiction?
In the states, I don't know which.
Almost all.
Almost, yes, almost all states in the U.S.
But you appreciate being Kenya?
Yes, I do appreciate. But that is why we borrow jurisprudence from others. And a mockery of what happened to the complainant is what is being propagated. And lastly, on the seriousness of the offense. The fact that a 57-year-old policeman who has given service to the Republic of Kenya for over 4 decades was assaulted while in uniform, dragged down. And this pained the members of the public who were there. but they chased after the accused person. You know, this offense is serious. It sends a message to the entire country. How do we treat our officers? How do we treat any member, any public servant? And it is my position that we have laid compelling grounds before you to deny the accused person, especially for the court to have the requests of the complainant at heart, who is the victim, to first testify before any consideration of the application for bond can be considered by the court. You know, the same is in the interest of justice to be all.
We're in the same team on behalf of the victim.
Yes, Your Honor. Perhaps before Mr. Omari addresses you, and now that he has confirmed that he's on the same team, you need to give the scope and direction to the scope of his participation pursuant to Section 9, subsection 2A of the Victims Protection. You know, in our humble view, Mr. Omari, at this particular stage, has now outlaid before you with respect to the matters before you. You know, this was held in the case of Waswa versus the DPP in petition number 33 of 2019, the Supreme Court decision at paragraph 7. Having confirmed that he is with the DPP, he cannot be a secondary prosecutor. His role must be very well defined. And he can only address the question of how will the granting of bail affect victims, if at all there was a victim. Because that now is an allegation that a victim exists.
So I think the jurisprudence on the victim, the role of the victim or the place of the victim in the trial process.
That's correct.
It's not in doubt, yeah?
That's
and
correct.
I think that citation, frankly, I think it's a guiding light on the issue of the victim. But obviously, I think the ratio in that matter is that the scope of the council watching brief of the victim is quite limited.
Yes, sir.
Because they cannot take the role of the DPP. As much as he was just about to be a DPP here. The role of the DPP in that matter, yeah?
Yes, yes.
So I think Mr. Omari, I think you're very limited because I believe the other council actually argued very
Well, I know exactly.
And Your Honor, before he submits, he can only submit on paragraph 8, clause E of the
that's
affidavit.
all what he has to say. Yeah, and
Because
then
that is what touches on the victim in this particular affidavit.
Well, I do confirm that that position of the DPP is not available for the next 7 years. So let him not worry. I'll address my point based on the complainant and the victim. I want to define who I'm addressing on behalf. The assaulted police officer is the complainant in this matter. His voice before the decision on bail the family of the victim voice officers in this country. That is the family of the accomplice needs to be heard. Let me start with the complainant, Your Honor. The charge sheet in count 2 reads that on the 2nd day of June 2024, committee road in Kasarani sub-county within Nairobi County unlawfully did grievous harm to one Jacob Ogendo. The complainant was grievously harmed. The import of that, in the event he dies, within 1 year and 1 day, the accused shall stand charged with the offense of murder. That is the first angle. Number two, the effect of those injuries need to be ascertained medically to bring into perspective the seriousness of the offense. Third, Your Honor, the victim is a 57-year-old police officer with children, with a wife, with the mothers-in-law and the fathers-in-law, with the uncles, who are looking at him, one as a failure, two, a 57-year-old brought down by a 19-year-old, that effect on his self-esteem is devastating. He will definitely need a lot of counseling. That is trauma that cannot be taken lightly. Well, I could have taken an affidavit from the complainant to bring to you. He's unable to swear that due to the beatings and the medical condition he's in. You know, on behalf of all the disciplined forces in this country, their creation is a constitutional organs that are created by the Constitution. Article 244 and 245 of the Constitution creates the National Police Service with the mandate to provide internal security. The symbol that Kenyans gave them for identification is the crown. police officer assaulted was wearing the symbol of national security, the crown. The attacker did not attack a policeman. He attacked the national sovereignty of the republic. He attacked 55 million Kenyans,
including himself.
That is how great this attack on a police officer is. Yona, what is the net effect of that attack? The American police services failed in Haiti. The world picked Kenya to provide police to go to Haiti. A confirmation that the Kenya police is the best trained. This image global is a serious dent to our reputation as a country. On our pride as a nation. So, the victims who are the police officers and all disciplined officers in this country, if they were not excluded from Article 37 of the Constitution to go picketing and demonstrating, by now all police officers could be on strike.
We invite them.
But we stopped them. And told them Article 37 E Avenue available, but don't release the accused person. On the fourth, the accused person is released through the Oscar Sudi decision by Justice Professor, but the police must continue providing security. Show me the practicability if you release this person, the public, from lynching him. The police will not stay. Therefore, for his safety, you will object.
I'm objecting. Your Honor, you gave parameters, and we are okay with the incitement that he's doing because it's on behalf of the victim. But when it comes to the point of now telling us that what will happen to the accused person, unless he has been given those instructions by his client, who he says is so ill, cannot even sign an affidavit, he's going outside your guidelines. I don't think that will be right.
I think what my learned colleague has said, he has said that these policemen are not willing to protect him. Yes. And initially, he had said that they are not on strike. He is confirming that National Police Service under Article 44 are on strike insofar as that young man is concerned, which is very prejudicial. And this court cannot entertain such submissions from an advocate holding brief for the complainant, regardless of how emotive the matter is. This is a court of law. Someone cannot come here and say that the policeman that this young man pays through his taxes cannot protect him. That is wrong, and Mr. Omari should recant that such statement.
Your Honor, additionally, I sought your guidance whether Mr. Omari's submissions should go outside the scope of paragraph 8,
It's about the victims.
paragraph E. If he would limit himself to that paragraph, this halubaloos that he's submitting on would not be in a position. You know, when he says that the young man cannot be protected by the police, and then you are being told don't release him, will you go with him to your house? Will he not go with will he not be taken to prison should you decline to grant bail? Are those not police officers? Where is the young man safe? Then unless Mr. Omari takes him with him to his house.
Your Honor, just before Mr. Omari proceeds, you have given parameters now which an advocate watching brief can proceed, Your Honor. It will be good for this court to stamp its authority.
Yes.
It is for such submissions, Your Honor, that the Supreme Court limited the role played by the advocate watching brief. He may be free to submit about the father-in-law, the mother-in-law, the cousin of this, of the police officer. But he should not be permitted, Your Honor, to purport to be speaking for the accused person who is ably represented. Do not mourn more than the bereaved. Do not wail louder than the owners of the funeral. We have our time.
And I think I've not gone outside the parameters of the victims. I'm talking on behalf of the victim, not the DPP.
How many victims are here? The family, the police,
Father-in-law.
the father-in-law. How many victims are here?
I have said in this matter, all disciplined officers are victims.
Yes.
All of them.
Your Honor, Your Honor, that is where you need to draw the line.
And we need to then elaborate.
The charge sheet is very clear. The national, Mr. Javere Koome, it's not a complainant. And my landed junior here, he's saying that the entire police service, or the entire, I don't know, what he must show us. And he has the charge sheet. Let him read that the entire police service is a complainant. He is only actually trying to poison the mind of this court by trying to show as if this world is coming to an end because a policeman has been alleged to have been assaulted by a citizen. Well, they're even invoking American jurisdiction, where we saw Drake Chauvin killing a demonstrator in the streets of America. That's the type of things that Mr. Omari is opening a Pandora's box because he's excited of the media. Kindly let my learned junior restrict himself.
Mr. Omari, don't be superfluous. Superfluous in your scope is limited.
All right.
Now you're trying to shift to the accused, because you're saying if the accused is released, I think that is beyond you. So just limit yourself because I granted you because I think a victim plays a very integral role in this proceeding.
And very limited ones.
And of course, limited.
Very well. You know, I've been told I'm junior. And I admit that. I'm junior.
The president of the...
I accept.
That is not in contention.
I'm the junior most advocate. But listen to that junior most advocate. Does he give what matters? It is not when you sign the law. It is what comes out of that brain. You know, while I'm raising this issue, charge account number 1. It's robbery with violence. And the particulars are that with others not before court robbed Job Ogendo of the battery of police communication gadget and a mobile phone. The import of a police communication gadget in the possession of an accused person is a grave national security issue. That is the person you are being told to release. And I urge the court to take judicial notice that police communication gadgets are a serious tool for the preserve of the police.
Again, Your Honor, we object that line of argument.
Could I get a checklist what they want me to talk?
Your Honor, I think
the objection to everything.
He's now going into matters that are out of his control.
That of evidential
the
nature.
affidavit is very clear where you are supposed to confine yourself to.
Your Honor,
we have not even
this
been starting with the
communication
gadget that he's talking
gadget
about.
was in the hands of the victim, my client.
Thanks, we know those allegations.
Yes.
So let's not, it's a fact, it's a factual matter.
Perhaps to manage, as Your Honor, you could give us indication of.
Let me give you.
If you gave Omari perhaps 2 minutes, he may.
I have only 1 more minute to go.
Alright, let's give him the 1 minute.
I have only 1 more minute to go. You know, the victims cry that before the court renders itself on the suitability of the accused being granted bail or denied bail, the court orders for a pre-bail report to bring to the attention of the court the actual circumstances within the community, within the family, so that the court will arrive at a fair and just decision to deny or to grant. But on behalf of the family, on behalf of the complainant, we completely object for the accused to be released on bail and his prayer is that he be allowed to testify. If the court will be inclined to grant bail or bond after he has testified and given his version before this court. That's all.
Alright, thank you, Mr. Omari. Now, that concludes the first team of the DPP and the victim. So we'll go to the
Yes, Your Honor,
all of you will be submitting.
we will be submitting, but we will take very limited time because we will really wish the court to make a decision today. First of all, we submitted extensively yesterday and took a lot of your time. In persuading you, Your Honor, to find it fit to admit the accused person to reasonable bond, terms or cash bail options. So, Your Honor, I would want to adopt, and that is the position of the defense, the submissions we made yesterday, mutatis mutandis, but over and above that, Your Honor, based on the Your Honor, we will demonstrate that in this affidavit, Your Honor, it is the prosecution itself as opposed to the victim or the investigating officer. That is perpetrating this. Your Honor, the prosecution, and it has made it a habit, I wish J.V. Witty was here, they have made it a habit to actually yell more than they yell the loudest, yet they are outside their collar. You know, no, that's off. That's off.
As we don't object.
Yes. Your Honor, if you look at the reasons that have been given, first of all, in terms of the legal parameters, Your Honor, we are all in agreement that bond is a constitutional right. We do not need to regurgitate that. The only thing you've been told, Your Honor, is that it indeed can be limited. And Your Honor, my brother J.V. rightly pointed you to Article 24(1). Very clear. It gives the fact that yes, a right can be limited, but it cannot be limited except by law, and the second qualification, which is very important, only to the extent that that limitation is reasonable and justifiable in a democratic and open society. The prosecution is now Your Honor, only to the extent that is reasonable, justifiable in an open and democratic society based on human dignity, equality, and freedom. And Your Honor, you've been further, and that second qualification is very important. It has always guided courts dealing with this matter, dealing with such objections and English from the prosecutors, to still affirm that they still have to convince you that that is the only available recourse in the circumstances. And to that extent, Your Honor, at this particular point, you have been given what they call compelling reasons. Your Honor, what they have told you are compelling reasons. Your Honor, you find them in only one paragraph and the subparagraphs therein. That is paragraph 8. Your Honor, you are told that the accused person, and the words used, went into hiding. And Your Honor, once you are told he went into hiding, what is not indicated in this affidavit, and that indicates the mischief in this affidavit. What you are not told is where did they find him? How long did it take to find him? But Your Honor, if the submissions of my learned sister, Virginia, are anything to go by, she has told you they found him in his mother's house. In his mother's house. Being a student, that is his place of abode. But they did not put it in this affidavit intentionally. Your Honor, if I leave this court and go to my house, that is the first place you'd look for me, or my office. Logic tells you that. But you are told going to your house is hiding. Then all of us hide at night and come back in the morning. That he's a flight risk. But more importantly, Your Honor, you have been told that even if you are to take judicial notice of that clip, and they are saying one of the reasons was that he was being chased by other people who were there. So to them, they would have been happy to tell you that he was chased or stayed there as a fool and was beaten and he died. If you are being chased, man, the nature of man is self-preservation. So even that alone will then dictate the circumstances under which then he was not at that scene, if that is anything to go by. And Your Honor, members of the public are relative. Kenya is made up of, I think, 55 million people at this particular point. So a batch of 3, 4, 5 people cannot be a representation of Kenya. So that when you are told there is imminent danger of public agitation as against the accused person, Your Honor, you would want to get the basis of this. What is the basis of this? Your Honor, the requirements of the Evidence Act and this Oaths and Statutory Act declare on an affidavit. You must exhibit proof of what you are averring. This affidavit is naked, Your Honor, as naked. And we've seen better affidavits from the prosecution. That tells you these people did not have any reason. They just did it because you granted them leave yesterday. This is an 11-page affidavit. And I've never seen JV in a matter with an 11-page affidavit, but it's okay, it's not here. Now, to that extent, Your Honor, you look at the 11 paragraph affidavit, and the first parts are just descriptions. But to that extent, Your Honor, when you are told that this person is a danger to the public, is a danger because of the public, let me rephrase it, because of the public agitation against him. Your Honor, first, it is the duty of the National Police Service to protect everyone, such that, Your Honor, what the deponent here is telling you is that that duty is a duty that they can exercise at the point that they want. They have a switch of on and off. that cannot be a reason, Your Honor, for you to say that based on the fact that you will not do your work, I will not grant him bond. Because if you don't grant him, where is he going? He's not going to Omari's house, as my colleague has said. He's going back to the police because they are the ones in charge of the remand. And these are people who are telling you, we will not protect him. Actually told you, we will not protect him. Your Honor, you are the only one who can protect him there. Police have said we will not protect him. They should not then be seeking to detain someone that they have said they will not protect. And Your Honor, while we are submitting on that, Your Honor, and there is evidence that not only have they refused to protect, they are at the center of circumstances of injuries to the accused person.
Objection, Your Honor.
Let me just...
My objection is simple, Your Honor. Matters of fact should not be coming from an affidavit or the accused person. Allegation.
Fair enough, Your Honor. If he had waited, Your Honor, you gave an order that the accused person be taken to hospital. That order, we have been told by the remand officers that that order is back here with a report from hospital. So if my colleague has not looked at it, he will have a chance. But I'm court.
Give us the letter.
Your Honor,
Your Honor, we have
Your Honor, it is the remand of life. We looked at it and I'll get back to this, but we are not leaving this issue. This person can't chew even the rat that has been I will. Yes. Your Honor, to that extent, we have aspect, Your Honor, that you are told that he's actually in danger, and then you are told that this is the public. And Your Honor, the reason for this victimization is what J.V. Owiti was telling you here. That the basis of this charge, and we have said it here, it is anchored on an illegality, corruption. It is anchored on quicksand. Demanding a bribe of 10,000 from a student. Your Honor, it's okay. It is okay. I will leave it there. I will leave it there. But there is judicial notice. Remember, they claimed on judicial notice.
Your Honor, if I could assist my colleague, when we was submitting on that, he's the one who preempted the issue of 10,000 bribe, so that we cannot, one of the colleagues cannot be saying this and the other one saying the opposite thing. It was raised by yourselves and you must live with it. Kindly.
My brief response is that Mr. J.V. brought it to the attention of the court that it will be raised. He did not raise it. He said they will raise it. And if they raise it, they should raise it through an affidavit. If not through an affidavit, through a report being made to IPOA, who are the investigative bodies of such issues.
Your Honor, let me save time, because I know what they want is to delay us and to delay the decision that will release my client. But Your Honor, even taking from what Virginia has told you, that in certain countries, she told you that such acts will lead to death. Your Honor, acts of corruption take judicial notice. In other countries, those public officers are lynched, leave alone being pushed to a trench. So these issues, Your Honor, you must look at them based on what is before you in terms of evidence. Your Honor, in terms of what you are being told by these indicated complainants, you do not have an affidavit. Because this is a person who should have deponed. In this affidavit that is before you, there is no indication that he is unable to do an affidavit.
You know, I did explain that he's in hospital, and we could have said, let us adjourn these proceedings until he recovers. He swears an affidavit. We have no problem. We can stop it here so that he swears an affidavit.
What we're relying on is what is before.
Is what is before.
So let's not impute that there are other affidavits. Yeah?
Yes.
So let's just limit, because that is the application. They are saying we're relying on this affidavit by the IU, we're relying on the affidavit of the complainant. So just limit it to what is before.
Your Honor, with respect,
Yes.
when the advocate of the victim spoke, he spoke extensively,
Yes.
and it is our duty to draw your attention, Your Honor, that there are matters of fact which he has pleaded that are to persuade you to deny. So all we are saying in response to all that is that if ever it was to have any probative value, it will have come in an affidavit format. And even if there was difficulty, which we will understand, at least it will have been in this document, such that those averments, Your Honor, have more value in law vis-a-vis the bond application in respect to the accused person. Your Honor, you have been told, as I wind up on this particular aspect, Your Honor, that indeed, if you look at that affidavit, and I'm happy you are drawing my attention to the affidavit, the deponent here, Your Honor, is not deponing independently as is required by law. He has actually told you in paragraph 10, and I want to draw the court's attention because this is now a legal issue. Your Honor, the deponent of this affidavit does not even believe that there are compelling reasons. His affidavit is based on what he has been told by another person who has not deponed. And he has not told us who specifically told him. Look at paragraph 10. It tells us that I have been informed by counsel handling information I believe to be true, that the reasons given are compelling enough so as to deny the respondent person bond. So this is a person himself, as the IO, does not even believe. So it is the fitina from this person called counsel that has been brought here and is actually telling you this is someone who I believe.
You're not kind of protect counsel.
No. That is the Kiswahili word. Your Honor, I got a name in Kiswahili. It is malice, it is gossip, it is hearsay. That is what I will rephrase it in those three words. It is gossip, it is hearsay. If that will make my brother happier. So that you remember the requirement under the Evidence Act is that it is this investigating officer who must first satisfy himself that after investigation, as he has indicated in the paragraph 7, 6 and 7, that I actually can aver that this person, there are compelling reasons to deny him bond. But the person who has come up with these reasons is someone who we do not know, and now they are running away from, I will say it's not to them, but whoever it is, Your Honor, that person is not before court. And you cannot then rely on this affidavit in terms of the strict sense of the Evidence Act. This is not an affidavit that can be relied upon. Your Honor, there are a lot of things that you have been told, Your Honor, and this is not the first case dealing with granting of bail or bond terms under the 2010 Constitution. It is not the first one, it will not be the last one. And neither is it the first one that the DPP is opposing. I've said they are used to opposing. Even the case that JV told you, they opposed up to midnight, but they were still granted bond. Because the Constitution, Your Honor, I submit, fights for all of us. It will fight for me today, Your Honor. It will fight for Ian Njoroge today. But the same Constitution, Your Honor, can fight for any of us in this room. And we have had, I've represented even magistrates with using this Constitution, and I've been with my brother.
Is that supposed?
No, it's off the record. You know, they say everything off the record. But